And is it Balle or Balle or?
Balle.
Balle?
Yeah.
All right. Balle versus Balle, case D08392854D. Counsel, if you could state your appearances for the record.
Neil Mullins, bar number 3544, with and on behalf of Cynthia Balle.
Andrew Taylor, bar number 8688, with and on behalf of Mr. Balle.
Now, Mr. Mullins, do we have a hearing set for you to withdraw, or?
Both set now. One's at 2 and one's at 2:30, and I was going to, if I could, combine both issues and then ask for the withdrawal at the end of the hearing so she at least has representation on all the issues.
Okay, so that was my question. You want to withdraw now, or?
I'll wait till the end of the hearing.
Okay. All right, did you both get a copy of the interview?
Yes.
All right. Do you have anything that you wish to, anything you wish to direct the court's attention to in the interview, or anything you need to address?
Yeah, just very briefly, Your Honor, if you, and whether you did or not doesn't make a difference, if you go back to the motions that were in front of you before we did the interview, we knew that there were going to be negative comments about Mom in the interview, and she's alleged all along, and we believe some of this interview helps, that on an ongoing basis, these children are being coached. She never had an issue with these children having a problem with her until she filed a divorce proceeding. And once she did, there's been cops involved, there's been disrespect against her mom, who's a grandparent, there's been calls at night during her visitation. There's constant communication between Dad and Petra, the oldest one, who she ended up having even a physical issue with at one point, that interferes with it. So we absolutely knew that during the pendency of this case, while this contentious custody case is going on, that those children are going to have some negative comments to make about their mom. So we've asked for evaluations, we've asked for interviews and stuff like that, but because of the financial issues that are involved in this, there hasn't been that opportunity. And I got to tell you, we both came to this court hearing last time. There were tons of issues that we could have argued with, but Your Honor spent so much time going through the pleadings that we had to limit it to, and understandably, limit it to what's going on. And the unfortunate thing is this is a family that, if there's not some intervention, in my opinion and my client's opinion, by someone that can see through some of the turmoil the kids are in because of the changes.
Counsel, at this point in time, I'm willing to appoint an evaluator.
That would be great. And then the second thing that we wanted to address, Your Honor, is the flagrant, and I mean flagrant, violation of the orders. So one little small portion of this presentation I'm making to you has to do with a point that I tried to make the last hearing, and you didn't let me, and I'm not saying you were wrong with it, but the bottom line is there has been 3 tax returns now instead of just 2 that are in front of me. And here's what's happening. And if you just bear with me for a second, it'll just take 2 minutes, and then you'll be able to know how to address
Just a second.
other stuff.
Hurry up with it.
In 2005, this gentleman's gross income from his chiropractic business, that he does not work full-time on, he only works a couple hours a day on it, generated $443,000 in gross income, $292,000 in net income. He then makes a voluntary investment in a bogus business called Digital Dojo. He takes a loss of $159,000 in 2005 for the business. The following year, he makes $417 gross, $295 net, just $3,000 higher, and then takes a $121,000 loss from that business. The following year, which is last year, his tax return that he wants my client to sign, and she won't because it's outright fraud to do it. He has a $323,000 income, $255 net, and then takes 2 big deductions. One, $53,000 from this Digital Dojo business, which he doesn't run and is not involved with, and another $57,000, and here's the big one, for a property that he claims he sold in his tax return but was foreclosed upon. You can't take a deduction of $57,000 for the difference in the sales price of a piece of property and not tell the IRS that it wasn't sold for the loss, it was foreclosed upon. Because as Your Honor knows, if you foreclose on a piece of property...
I don't know. You're talking
Well,
about taxes, and
Well, when the IRS forecloses on a
I'm
piece of...
blissfully ignorant when it comes to
When a bank
taxes.
forecloses on a piece of property,
They get a judgment, they charge it off, and they
well,
write
the
it off.
IRS has the right to say that the amount of money that was
Okay.
forgiven on a loan is income. The
So-
bottom line is, he's got affidavits in front of you saying that his income net is about $123,000 a year. Now, you can liken this to me tomorrow, having an income of $300,000, choosing to invest 150 of it a year in IBM. If I lose the investment, I don't get to come to court in divorce case in front of Judge Potter and say, I make 300 grand a year, and last year I invested 150 and lost it. So therefore, I want my child support to be based upon, and my alimony to be based upon this amount of
Well, have
money.
you gotten any documents regarding this business at all?
I have the tax returns to show it.
For the
We have
for
Digital
Digital
Dojo.
Dojo.
This is what he did with Digital Dojo. He has a partner. He bought a house and let the partner live in the house, and then he paid all of the partner's expenses. It wasn't, I mean, I'm sure there was equipment purchase and stuff like that, but the bottom line is these people were living in a house rent-free, and then he was taking the money that he was paying the rent for and claiming that that's a loss for the business, and at the same time telling the IRS then when he gets foreclosed upon for failure to make the payments, that he gets a deduction for it.
Judge,
The point of the matter is this, and I'm done with the financial analysis now. The point of the matter is, you took his representations made in his AFC that he makes 144 grand a year at the last hearing, and then you issued an order about how he had to pay her $6,000 some odd dollars a month for child support and alimony, and you made an order for him that he had to pay $2,500 a month for legal fees that he didn't pay. Now, my legal fees to date, after getting paid a $5,000 retainer or something like that back in the early part of the summer, are at 11. If I get an order from you today that he has to pay my office directly, and I mean immediately, the $7,500 that should have already been paid, I'll reduce the balance of the bill against Cynthia down to the 11, and I'm done. But he also ought to have repercussions for violating that court order with knowledge now for more than several weeks that this matter was coming, knowing that his single mother, wife, is trying to represent herself in court with the kind of financial analysis you can imagine a lawyer has to go through to get this done. That she doesn't have the
Bottom
resources
line,
to do.
Mr. Mullins, what specifically do you want me to do today?
It's easy. I want you to address...
It would be easy if you would tell me
All right.
specifically
I want
what
you
it
to-
is.
I want you to ask him in court why that money wasn't paid and find out why this lady...
What money?
$7,500 attorney fees you ordered.
Okay.
30 Now here's the other thing. I
No,
prepared.
don't backtrack on me. We were making some progress. You want me to ask him, why haven't you paid $7,500 in attorney's fees?
You want me to answer?
Yeah.
No, I don't have it.
Okay, thanks. What's
I
next?
don't have it.
All right. I guess that's it. You
That's
know
his
what's going on.
answer.
You've got the
Truth.
Okay, but you're not asking me to modify any of the previously set
no, your
amounts.
financial orders are fine.
Okay.
But I want you to look at those.
Why the heck am I listening to you for 15 minutes? That's time I won't get
Well,
back.
Your Honor, you just
No,
say,
I'm-
okay,
I'm-
that she has no lawyer.
No.
The case goes on. She has no representation.
I
and
got
gets
you.
away with all this.
I got you. So the attorney's fees.
Now, the last thing is, regarding the kids, the custody situation, they didn't succeed in getting a parenting plan signed. At some points, they thought they had that worked out, but they need a holiday schedule so that when they come back to court in front of you, Your Honor,
All right,
they'll have that done. Thank you.
counsel, briefly.
Judge, I will be brief. On the family court mediation, I want to draw your attention to page 2, paragraph 1, 2, 3, paragraph 4. It's very clear that the children want actually the time to be reversed rather than spending the bulk of their time with their mother. They want to spend time with their father. That's the first point. Second point,
Why don't you tell me why they want to spend the time with the father and show me some factor in there that leads me to a best interest analysis?
well, when the
Because
kids...
the only factor I got out of the whole thing was fun, and fun's not a factor for best interest.
It's not. Recognizing they do enjoy having spent time with their father. When they're with him, he does their homework with them. He spends time with them. He takes care of his kids as he should. apparently, if you look at,
Does it say homework and stuff in there? Because let's see, I got Las Vegas, California, play games, go to movies, watch videos. We do nothing fun with mom.
He's got him on the weekends. She hasn't.
I only have them on the weekends, yeah.
Okay, so all right,
but,
all right.
Kinda
but he does
tough
do
to-
homework with him, Judge, and he does do things that a father should. And that being said, he works more than 2 hours a day at his business. He works a substantial amount of time. That being said, he does have time he can spend with them. He could spend, more than just a weekend with his kids. They clearly want more time, and he has the time he can spend with them.
She would love a thing where they share weekends and share some of the weekday responsibilities if that's what he'd like. Because right now she only sees them for the homework days during the week because he's got every weekend.
Well, do we need a PhD for our outsourced evaluation on this one?
I would think you would.
Your client's gonna have to pay for half of it.
As long as the court's going to honor the awards regarding
Yeah.
the financial orders you've
I'm
made.
not modifying any of the
Judge-
financial orders today.
Do we need a PhD if both parties want to spend?
Well, that's what I'm saying. Do we need a PhD? We can save you some money and
You want
send you
to do a
to.
marriage family therapist? That's fine.
Because I'm looking at.
Because if the plaintiff is going to school, the plaintiff is spending time away from the kids. She wants to do her thing.
Look, I'm looking to try and save you some money. I'm looking at Jack Cathy or Donna Gusnell. Deborah Roberts. Anybody have any preference?
The first and third one you just mentioned,
Equal Wyford, Donna Wilburn. What?
3 of the 4 are fine. I'm not a preference of Donna Gosnell, but the other 3 are fine. Either one of the other 3 are fine.
Paul Wolkin.
Paul
He's
Wilkin.
never mind. He's.
But Jack Cathy,
No preference,
Deborah
Judge.
Roberts, or
Let's go with Jack Cathy.
that's fine.
I like his reports. So I'll need a outsource referral. I'm not sure where Sherry's got them stashed.
Now, Judge, we do have a proposed visitation schedule if they would be interested in entertaining it.
Well, you can talk about it amongst yourselves while I fill this out really quick. Then, Brad, if you can give them each my standard holiday schedule.
Oh, yeah.
It's not
I got it.
He didn't agree to You want what? Say it, Ben?
Oh, he did. Thank you.
He's going to have you tell it to Donna Gosnell, who's going to report back to him.
Jack Cathy.
Jack Cathy, I'm sorry. What's that?
Monday, Tuesday.
I thought Donna was the one you said you didn't.
During the pendency till you come back, his offer is, would you consider doing Monday, Tuesday, and Wednesday, Thursday? Weekend alternates till you come back to court. We would have the weekends stay where they are.
They're looking at it.
Problem
With the baby, no way.
is she'd be conceding half the week when the issue is still contested. He backs a day off and shows you.
One day out?
No. I don't think they did, dude.
What if
No.
he-
Look, have either of you guys read the Rivero case yet from the Supreme Court
Regarding schooling, is that the one?
regarding joint physical custody?
Rivero?
Yeah. Let me elucidate you.
How recently was it?
Very recent, October 30th. The Supreme Court has now defined joint physical custody. They accepted the definition that exists in Missouri that states joint physical custody means an order awarding each of the parents significant but not necessarily equal periods of time during which a child resides with or is under the care and supervision of each parent. Joint physical custody shall be shared by the parents in such a way as to assure the child of frequent, continuing, and meaningful contact with both parents.
How do you reconcile that with primary then? I don't even know how to do
Well, what you have is you have a primary and a secondary, but it also has a component in it that modifies child support that you can take a look at
I
and
will.
takes into account the time weighting factors. with the new definition, I don't know that, it doesn't matter how we count up the hours, is all I'm saying. You know, we used to fight not to have a 50-50, and now at this point in time, with the definition we've got, I'm not sure that we need to worry about hours in the day and days of the week as much anymore.
I'm going to whisper to council for just a second. It could help us.
Well, I need to call another case here fairly quickly, guys.
Plus every other weekend.
No.
We have a
Same
return.
amount of time as her. I'm done. Same amount of time as her.
Tuesday.
Well, I mean,
Nope. I want the same time. Okay? So don't even bother.
I'm not talking about permanent. I'm talking about
I'm talking about now.
Put it on the
I
referral.
want the
and
same amount of
let me
time
know
as
what
her,
it
if
is.
not more time than her, because that's what my kids want.
Yeah, that's something else.
Do I do all
I don't
the
think we can't, not on an outsource.
What we're talking about now is trying to change what the judge is ordering, which is this weekend.
20.
If they'll give us,
I'd rather just have the weekends on.
okay,
You know what I'm saying?
all right.
The kids want to be with me, dude, not her. They can't stand
I know.
her. Or her. They hate her.
I know, but I mean, the
That's all
point
it
is,
those issues.
right now, they're willing to agree
But
to
that's
do
why
that.
he's sending you to Jack Cathy. She wants to make a comment to you, Your Honor.
Trust me
know.
on this.
Oh, I know.
I'm not scared. I'm not hiding nothing.
Your
I'm
Honor,
not scared.
You gotta stand.
there are just a few things that I think that you should know about, and this is very recent. The baby's birthday was the 25th of October, which fell on a Saturday, and the temporary order said that he gets them from Friday afternoon till Monday morning after school. I had called and requested some time with the baby for a cake with friends on the Monday, and he emailed me that he would have to deny my request, and he would not let me see the baby on his birthday.
Okay, thanks.
He's
Not true. I said she could.
Stop!
the second one.
Stop, please, just stop. I mean, go file a TPO, go file a criminal case, file the appropriate motion. I believe in parenting. I believe that children do what you tell them to do. Children don't drive the family, okay? So the fact that I got 3 kids telling me, and you think I'm going to, just because they tell me that they want to spend more time with you, I'm going to order it, that's crazy. That's crazy. Because I might be an old-fashioned hardcore parent, but I'll be damned. I'm going to let some 13, especially a 13-year-old girl, tell me how she's going to raise herself? Not happening. Not close. That better be one special 13-year-old before I'm going to take just her whim into consideration. Now, these kids could have cited relevant factors that relate to determining the best interests of a child, which would indicate maturity and an understanding of the situation, then I'm more than happy to listen to them. But like I said, all I got out of this report, all I got out of this interview is fun, no fun. But that's not all. I mean, there are a couple things in there, ma'am, that you need to be very cognizant of. You cannot badmouth Dad when you're gabbing with your sister, your mother, your friends, anybody else. Even when the kids aren't there, it shouldn't cross your lips. Write it in a journal. Keep the journal under lock and key. Do not let your children have access to court records or documents. Neither one of you should be attempting to coach them. We've given you the outsourced evaluation. At this point in time, I think an expansion of the visitation may be warranted, but you know, I'm not entirely sure how to make that work. And so, you know, Mr. Anderson or Taylor, I'm not sure when is your client available. Besides, I'm giving him the weekends, which is all of his apparent available free time.
Your Honor, truthfully, I'm
Or is he only working? If he's, I mean, they claim he's only working a couple
No,
hours a day
no.
at the things.
No,
so-
the fact is that I'm only in my office a couple hours a day, but I do marketing for my office and management. So I'm not in the office. Like I don't physically have to be there. I work 24/7.
Well, then you definitely don't need to have more time. If you're working 24/7.
No, I'm saying I could be with my kids because I work on my phone.
You can't have it both ways.
I'm saying
You
I'm
can't-
available
No,
to
wait,
do.
wait. Time out. Here's another parenting nugget from Judge Potter. Multitasking doesn't work with kids. You're either working or you're parenting. I try and do both, and it slows the work down. That's why you're working 24 hours a day, because you're trying to multitask. How you work when you got kids running under?
Well, it's not that I have work to do 24
And how
hours
do
a
you
day.
pay
it's that-
attention to your kids when you're working? It doesn't work that way.
Judge, that being said, I think he can
All
take some...
prior orders will remain in full force and effect. The $7,500 that was awarded, Mr. Mullins, that's reduced to judgment, subject to all interest and penalties collectible by any lawful means. Put liens against the property, do whatever you need to do.
The property's gone. I was hoping you were going to make it
I,
directly against
there's
him.
probably he's probably got a cash register or something in the safe in the office. Get the sheriff down there and seize it.
Okay, Your Honor, so I'm
Take his car. I think they've got some paid off assets. There might be an X-ray machine in there.
Right now, what I have is that the judgment is against my client because I don't have a remedy against him. Now that you're making an order that I can go directly with him, I'll submit a second order on that issue to Your Honor. But for now,
He's the one that owes the money.
okay.
Didn't I? Wasn't that my prior order? Was it he owed you money?
You ordered preliminary attorney fees
There's a court case. Hold on a second. We'll talk
in
about it.
general without saying it that way. But now I can interpret it that way and submit a second order, and then I'll have you sign that against him in judgment.
No, those.
And apparently he's got a motion to set aside that in front of you that I'm not going to be here for. I think we're done.
We're done.
Are we-
What was our return date on the
We're going to see a PhD.
March 5th, 2009 on the return from the outsourced evaluation?
But Mr. Mullins is withdrawn, is that correct?
Yeah.
2009.
Written right there. I'll explain that in the hall.
All right.
Okay,
Page
outsourcing
10.
evaluation.
Okay. We need to throw you out quick. I got other cases to call up. Hoffman versus Grames Hoffman, case D08387296D.
You ready? Let's go. That's it.
Now this one, we have a divorce. Do we have a trial set for this one? Divorce? Yep. In March? That's gotta be, it's gotta be for something else. All right, Balle versus Balle, case D08392854D. Counsel, state your appearance, please.
Andrew Taylor for Mr. Balle, who is present.
I'm sorry.
The judge asks who's present.
No, I just asked you to state your appearance. I know that the parties are here. We have a return hearing set in March for mediation. Are the parties going through private mediation or?
We're having an evaluation done, a professional evaluation, Judge. If we get one soon, we can.
Need to make that change. All right. So, Mr. Taylor, your client pays
$6,700.
$1,153 for health insurance. Who does that cover?
Everyone, the whole
Covers it.
family.
The whole family, Judge.
And $1,206 a month for life insurance?
Yeah.
What kind of life insurance is that?
It's like a $2 million policy. I think it's a term or a universal life.
I'd quit paying it if it was universal, but that's just me.
I'm thinking about it. I actually have a second
Who's
policy.
got the $846 a month car payment?
I do.
Both parties do.
No, I do. I do.
Both cars, right?
No.
Just the one?
Yeah, and hers is $785.
And then $433 a month for 2 cars?
Yeah.
For insurance?
Yeah.
Or
It's
accidents or...
No, it's a 100-300 with $1 million umbrella,
Okay.
full coverage.
And ma'am, do you have an income that's independent of your husband?
No, I do not. And actually, Judge, I just, are you looking at his affidavit that was filed on August 7th?
All right. Now, Mr. Taylor, your client, the house that was the marital residence has been foreclosed,
That's correct, Judge.
so there's no payment being made on that home, correct?
Correct.
And mom he's no longer paying any rent or more house payment for her. You pay that out of the money, out of the funds that you're provided for child support and temporary spousal, correct?
It could be $2,100 a month.
And she makes the allegation that he's only paid a couple of months of the children's private schooling and so forth, and she's been paying the rest of that out of the monies that she's been provided. Is that correct, counsel?
It is, Judge.
And for the record, that's $3,000 in child support, and then
No, $3,720 child support.
$3,720 in child support, $3,000 in alimony.
your client file an updated affidavit of financial conditions or
We haven't, Judge.
disclosure?
We have a year earlier and a year more recent tax returns, but it doesn't change anything.
Well, his expenses would have changed. I believe would have changed at least to the extent under the last time he filed. I believe he was still making the payment on the marital residence and claiming the children's schooling.
That's true.
So I mean, my problem is I understand what he's telling me is he's got a lot of expenses that he thinks that I didn't take into account, but I kind of need to see the financial disclosure form so that I can make a determination as to what's the appropriate amount.
Okay.
Under the current payments, if mom's paying what are your expenses, ma'am, that you're paying?
I am paying $2,100 in rent now for the house. I'm paying the $850.
Now, this is for a different house, or are you paying this?
This is a rental house. Yes.
Okay.
We had to
All right, that's fine.
paying the $855 for the children's schooling.
And that's a monthly?
Yes.
He has 2 kids in private school.
I'm paying right now the $785 a month for the Suburban, which I'm wanting to get rid of and get a more affordable payment.
Well,
All the utilities, food,
okay.
and if I can say something, please, Your Honor. On his affidavit that you were looking at just now, he swore and signed that he was paying the $7,800 mortgage on August 7th, but you
Okay,
can see by the
ma'am,
exhibit,
ma'am, listen.
it
Look,
wasn't.
fine.
Those are my
Look,
expenses.
We just can't believe anything he's telling the court.
ma'am,
Be quiet, please.
first of all, I'm not going to modify the visitation schedule until we come back from the evaluation. If the parties can agree to modify the visitation schedule, go right ahead. If you still owe money on the Suburban, there is no title. Okay? You don't get title until the vehicle's been paid for.
Correct, I wanted to
Title and a car payment are mutually exclusive.
But I wanted to trade it in and
He
pay.
can't give you a title. You asked me to have him give you the title. There is no title to give you.
Can he sign it off to trade it in?
The thing is, Your Honor, the trade-in doesn't help her get another
Well,
car.
maybe it does. Maybe it does.
Well, she
I
already
don't
told
know.
me it
I don't
doesn't.
know. The bottom line is, ma'am, you got to go out and you got to find out what you can do, and then you can contact Mr. Taylor. And
okay.
if they refuse to cooperate, then you can file the appropriate motion. If she finds some way to trade the Suburban in and walk off with a Kia or something that has a much lower payment, even though she's paying them basically to take the Suburban off her hand, people do that regularly.
Right. Well, the only thing else.
So listen,
No.
just stop,
I
okay?
want the Suburban for the kids because I can get rid of my car. That's
Then work it out.
that's what I was trying to do, but she's like not letting me do that.
All right.
She only wants me to sign the car off to her.
No, Your Honor, I just
Stop! None of this is in the papers, and I'm not gonna sit here and mediate your divorce dispute. I don't have the time. There's plenty of places out there you can go and find a mediator. I'll give you both a card for former Judge Gaston. And as for the attorney's fees, there was a judgment ordered, and that judgment can be collected by any lawful means. So at this point in time, the court is going to deny the motion to reconsider without prejudice. The court is going to deny requests to modify visitation. And regarding the Suburban, you're probably better off. I imagine you're upside down with the Suburban. There's a negative equity there.
very little.
Probably better off going out and buying a new car than trying to trade in a vehicle that has no value.
Your Honor, that's what I'm trying to do. I just
Well,
want to make sure I'm not going to be held liable for
he
that
just said-
also.
You want the Suburban?
That's what I said.
He's going to take the
Or
Suburban.
that he's going to tell you now he has 2 car payments,
Well,
so he cannot pay me.
He's on the record now. He
Okay.
wants the Suburban. He's going to take the Suburban. He's going to have to find a way to pay for it, turn in the other car, take the kids out of private school. You guys have enough income that you can make this work. Nobody's going to the poorhouse yet. And he says he'll take the Suburban. So give him the Suburban. It won't be held against you. And whoever winds up with the vehicle winds up with the encumbrance.
Judge, as to the Suburban, she is behind on her payments.
Well,
I'm trading it in.
you know,
Pay
the
it off.
bottom line is, if he wants it, he can have it, and we'll relieve her of the liability that goes along with it. All right? Thank you. Good luck.
Judge, one follow-up.
Yeah?
If we could,
Are you sure?
yes.
Okay.
As my client does have the kids for almost half the week, he has them Friday night through Monday morning, almost 4 days. We're wondering if we could get some sort of offset on the alimony or child support because he does have the kids for at least.
From Friday night to Monday morning?
Yep.
You and I must count a little bit differently.
Saturday, Sunday, Monday.
Friday.
3 days. Friday night, Saturday night, Sunday night, Monday night. 3 days.
So 2 days and a half, basically, from Friday night to Saturday night to Sunday night to Monday morning.
That's right, I miscounted.
You know, at this point in time, like I say, I'm not going to modify it. File an updated financial disclosure form. You know, it appears to me that I don't think anybody's hurting yet, and she's maintaining her rent, and she's maintaining the private school, so she's obviously has sufficient to provide the necessities. And if she's able to get out of the suburban payment and obtain a vehicle that's cheaper, then there's going to be grounds both ways to potentially modify. But we need to get the disclosure forms filled out so that I can look at the income and the expenses and see what the need is and what the ability is. All right. I'm going to ask you just prepare an order from today. The request to modify the financial issues is denied. The request to modify visitation issues is denied. And we'll see everybody back in March.
Your Honor, regarding the first evaluation, that cost is $3,000, and half of it has to be paid up front. I don't have it. I don't even have an attorney.
Well, at the time, did I order both of you to pay that 50-50?
Yes, and I can't afford it. I can't do it. I cannot participate in it.
They're charging both of you $3,000 up front?
No,
15.
15.
All right.
I don't even have an
Look,
attorney or legal fee.
I know that, ma'am. I know that. Sir,
Money. I'm giving it all to her.
the bottom line is pay it, and you know she's responsible for half of that, and it'll come off the back end. You've got a business that's going to be valued, or it'll be taken into consideration at the time of trial and division of the property.
Still give her the $6,700 plus pay the $3,000.
Can. Yep. All right. Thank you.
Your Honor, if I can just ask, what about I'm sorry, we have extensive medical bills that are due.
File
for
the
kids.
appropriate motion. We'll impose a 30-30 rule. Each party should pay out of pockets 50-50. All right. Good luck to you.
That doesn't include her medical expenses, does it?
No.
Thank you, Your Honor.
Page 5.
Individual to do business evaluation.
All right, this is case D08392-854D, Balle versus Balle. Counsel, if you could state your appearances for the record, please.
Chelsea Campbell, bar number 11865, representing Cynthia Valley in an unbundled capacity.
Andrew Taylor, bar number 866 for Mr. Valley, who is present.
Okay. Do we have an order filed yet in this matter?
We haven't, Judge. I was going to prepare it. I've been out of the country for the last week and a half and didn't get a chance to do it before I left.
How soon before it'll be filed?
It'll be this week. So I'm still sort of catching
Tomorrow's
up.
Friday.
Has your client paid? She alleges he's not paying any of these amounts. Is he? I hope he's not willfully not paying just because he doesn't have an order yet that says he has to pay it.
Your Honor, if I could interject.
Hold on a second. What? Go ahead.
She's filed an order.
Ah, I wasn't aware.
Okay. She just filed an order, so that should be, apparently it was logged out and on its way to be filed.
Yeah. Okay. I see it. All right. So, Counsel, you received a copy of their motion, obviously.
I got it Tuesday.
All right. Do you have any documentation, anything to indicate that any of these sums have been paid?
I think the only dispute, Judge, was an amount for the car she had not been paying. On August 20th, she was ordered to pay for the car, pay for the expenses of the car. She failed to do so, and I believe he deducted that amount for a couple months or whatever she had not paid. He was getting phone calls from.
He's got proof that he paid those monies towards the Suburban.
Just the checks, the canceled checks, I guess.
Well, I mean, proof is proof.
Yeah.
Provide that to the plaintiff.
We'll provide that to her.
Yeah, I don't have it with me now.
And then no more deductions. If she doesn't make the payment, then
Well, I have the car now, sir. So that's done.
It won't happen again.
Your Honor, it was stipulated that actually he would be taking care of the car On December 3rd.
Right.
All encumbrances, so we don't know.
I pay. That was in October, November payments that I took out, not anything after December.
All right. All right,
Yeah, I didn't even
Mr.
deduct the
Taylor,
$75.
we're going to put this back on in 2 weeks. Can you get me a written opposition filed this week?
I will, Judge, and I'll include copies of checks, canceled
All right.
checks.
And provide all the documentation, and make sure he's current on what his responsibilities are.
Will do, Judge.
All right. We'll see you back in 2 weeks on.
January 29th at 1:30.
January 29th at 2:30?
1:30. Oh, hold on a second. Is there a reason that the TPA request is being made of me and has not been filed with the actual protective order office?
It was stated to come to you, that you would, the other judge threw it down to you, basically.
Okay, so there was a hearing at TPO
And
court
he
and
said
everything
for
was
you to
just
resolve it.
continued? All right, can I have both parties stand, raise your right hands, be sworn in?
You need to do solemnly swear the testimony you're about to give this action should be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
Okay. We're here on a hearing required to issue a TPO. Ma'am, can you please state your name for the record?
Cynthia Balle.
You've applied for a protective order,
Yes.
and you wish to have a protective order issued at this time?
Yes.
And can you state for me why you feel that you need a protective order?
This is just not an isolated incident. There has been this kind of thing happening in the past. He has no boundaries, and if he gets angry, he'll do whatever he wants to do, how he wants to do
Can you
it.
tell me about a specific incident that happened
Yes.
sometime recently?
Yes. He tore jewelry off of my neck and my earrings out of my ears. And then when I tried to shut the door
When
on
did
him
this happen?
at my house when he was dropping off the baby,
Can you give me a date or approximate time?
it was, I believe, December 8th on a Monday. That was the Monday. It's in the filing. Was it?
So December 8th?
Yes. When I tried to close the door, he kicked the door open.
And police were called?
Yes, I called.
What happened?
After we left. I gave them the incident, told them what happened, and they told me what to
Have
do.
you had any further contact with the law enforcement at all?
No.
Did they take pictures?
No.
Do you have a written report from them?
Yes. And an event number if you needed it.
Counsel, has your client been contacted by the police at all?
No, Judge.
Oh, well, they just served me that day.
Oh, that's right. Just with the order of the TPO, not other than that.
All right, sir, what happened on December 8th?
Basically, what had happened was the Friday prior to December 8th, my son grabbed my guitar that she was in possession of and put it in my car, and I proceeded to take it home with me. And on Monday morning, as I was taking the kids to school, she calls my daughter's cell phone complaining that she wants the guitar back and that they had no right to take it out of the house. And she basically accused my son of stealing the guitar from her. So when I got to the house to drop off the baby, because we don't have anywhere to drop off the baby because he's not in school yet, she proceeded to tell me that she wanted the guitar back. And I told her, how can you have it back when it's not yours? It's mine. You never had it in the first place. She says that it's her guitar because she bought it for me. And I said, well, if that's the case, then the jewelry you're wearing is mine because I bought it for you.
And that's it?
Well, no. So what happened was, I actually had a hold of the jewelry, because she has a pendant. It's like a wreath pendant with sapphires and diamonds around. It's like a circle. And I was holding it and I said, I bought this for you. So this is mine. And she like tugged back and the neck was snapped. It's like a really thin gold necklace. So anyway, so she went into the house and tried to slam the door, and I put my foot up because the baby was still on the porch. And what I did was I took the jewelry and I threw it into the house onto the hallway and said, I don't want your jewelry, but you're not getting my guitar. And then I grabbed the baby and I put the baby inside and I said, bye, have a nice day. And I walked out.
Your Honor, that is absolutely untrue.
Ma'am,
Baby
sit
was
down.
not even-
Sit down. Okay? It doesn't matter. That's a sufficient enough basis under the laws regarding protective orders for me to grant a protective order. What is it you do, sir?
I'm a doctor.
Okay. You don't have a concealed weapon permit.
No.
You don't carry a firearm.
No.
You got kids, sir. I'm sure, and you got some that are young enough. I'm sure you hear the sticks and stones old nugget all the time. You know, it doesn't matter what she says. It doesn't matter what she does. You're not the one to initiate contact. Contact includes anything that she has in her possession. If she's holding a phone in her hand or a bottle or she's wearing a necklace, you can't touch it. You can't grab it. That meets the definition of domestic violence. Okay, putting your foot in the door to stop her from slamming the door, that meets the definition. It's a very slim definition. You don't have to do a whole heck of a lot to be convicted, or even less for me to extend a protective order against you. Is there some place, some neutral location where you guys can exchange the toddler?
One of their schools.
Ma'am, is there some neutral location where you can exchange the toddler?
It's at the school. Middle school.
We only have to deal with it on a Friday afternoon or on Monday right now.
And so can we just shift the time for the exchanges to coincide with the time that you're...
That's kind of what we've been doing, sort of. But the thing is we have kids in two different schools. One of
I know.
she at first was dropping the oldest one and the youngest one off at the two middle kids' school up in Summerlin. And then on Friday, she decided she didn't want to do that and wanted me to come all the way out to Centennial Hills to pick them up at 2:15 and then go get the kids at 2:45. So it was a big issue on Friday as well, getting them.
You guys have an order that sets forth where you're supposed to do the exchanges or anything?
No.
Not specifically enough, Your Honor. It just says pick up at dismissal time at Friday. It says Friday after school till Monday at school drop off. One of them gets out at 2:16, which is right there by the
All right,
house.
let's do the exchange at the middle school at the time of that exchange, and it would be appropriate to have Petra have her come to whoever has the toddler at the time, come to that vehicle, and then Petra can assist the 2-year-old to the other parents. That way you guys don't even have to park in too close a proximity to each other, and that'll resolve those issues. Look, at this point in time, I'm not inclined to grant the protective order. However, I am going to issue an order in the D case. And that order, sir, is that you are to have no contact with the plaintiff in this case other than through email or text message. If you need to communicate with her for any reason, those are your methods of communication. Or if there's a fax machine, you can communicate by fax. Everything has to be in writing, all right? It goes for you too, ma'am. I don't want to have any options, he said something, she said something, and not have some kind of documentation. Feel free to videotape any exchanges of the children. There shouldn't be any exchange between either of you at all whatsoever. If you are at events that you're both required to be at for the children or for whatever purpose, you need to maintain a significant distance, at least I'm going to make it 40 feet. Okay. I don't want any verbal communication between the two of you. I don't want dirty looks. I don't want hand gestures. I don't want anything. Anyone I find to be in violation of this can and will serve 25 days in the Clark County Detention Center for each and every incident, and the issuance of an actual temporary protective order against domestic violence will be reconsidered. Is that understood, sir?
We have one additional issue, if I may. Around the time of New Year's, the plaintiff took the kids out of state to California without my client's knowledge. I believe they were gone Tuesday, Wednesday, Thursday, Friday. The daughter ended up calling and notifying my client that they were out of state.
Counsel, did he miss his scheduled visitation?
Yes, he did.
All right. Look.
With his permission, Your Honor.
Well, look. You guys are going to be on the fast track to spending lots and lots of money on child parenting coordinators and having outsourced evaluations and having somebody else tell you each and every time that you're going to get to spend any time at all with your kids, and me calling Child Protective Services to claim that you're both unfit because obviously you can't agree on even the simplest things regarding your children's welfare. So you need to make sure, and that's why it's all going to be in writing from here on. Everything's going to be in writing. Okay? Follow the orders. Yes, ma'am?
I may interject. On the motion that she filed to show cause, one of the issues, and again, thank you for the order, was that I believe there was communication with the oldest daughter.
And you've already ordered on August 20th that all communication was email and text messaging, and he's violated that already by not doing it.
All right. We'll see you back on August 20th for the financial issues.
Thank you, Judge.
Oh, what, January 20th?
January 20th.
The date? Right. Oh, the 29th.
Yeah.
Okay. All right. I wrote down the wrong date. January 29th at 1:30, right?
I'll file an opposition, Judge. Thank you.
Page 8. Okay. Johnson versus Johnson.